All right, let's get more on this then. We have Mpumelelo Zikalala, who's a legal analyst and attorney at Zikalala Attorneys, to speak further on this for us. A very good evening to you, sir. And thank you, as always, for agreeing to talk to us here on SABC News.
Good evening to you, and also good evening to your viewers.
All right, so obviously we've gone through this before, in the first trial, where it seemed as though there was what some called incompetence of the police that were handling the scene. We're back here again. What's been your view now of what Thabo Mosia has now had to say this time around?
I think now the level of the lack of not being able to do things in a proper manner has been proved time and time and again.
Yeah.
But I think he's more accepting now, and he accepts that yes, there are mistakes which are going to take place. But what matters the most is, do those mistakes warrant that the evidence that has been collected that it must not be used at all? Or is there enough evidence to place those particular accused that are sitting in the witness box to be able to say and prove to the court or prove to the judge that indeed they are indeed the correct individuals that perpetrated this crime, and that the individuals that ought to be punished at the end of the day. I think now we're moving towards the process of saying, I acknowledge my mistakes. Yes, I did do mistakes, but they're not pertinent or material enough in order to warrant that the evidence which I'm presenting to you at court today must not be considered by this court, accepted despite the mistakes that has been provided or that I have highlighted to you as the court.
Yeah. And, one of the interesting things that, of course, we have found out during the course of this week was that the Meyiwa incident was only reported to South African Police Services 4 hours after, the situation had indeed taken place. What does this then say about, what took place? And does this lean to the fact that perhaps the people in the house actually have more to say as to what happened? Because my understanding would be if someone is shot, they are quickly rushed to hospital and, almost immediately it becomes a police case. The fact that we're talking about a 4-hour lapse, is quite concerning, from whether we're talking from a moral point of view, but from a legal point of view, what does it say anything?
It does. It certainly paints a picture of the individuals that were in the house that did not think that their first point of reference should be the police. Now, the most natural thing to do, if anyone has been shot, anyone has been hurt, there's been a robbery, the one thing that you want to do is to call the police so that they can come in. Secondly, even when you go to hospital, you still want to register that particular incident that has took place so that police can go and be able to secure the crime scene and be able to get the evidence, which is going to be crucial at the end of the day in the investigations that are going to come at a later stage. Now, in this case, the people that were in the house cannot explain as to what was happening within that 4 hours. And on that basis, it fits exactly to the narrative from the accused in terms of saying, the individuals that perpetrated this crime are not external individuals. They are people that were in the house at the time. In fact, the delay in them calling the police is due to the fact that they were still trying to find ways in hiding things, still trying to find ways in which they are going to come up with a principal story, because they were all in this together.
Yeah.
So that may be a narrative in which the accused would want to paint or to provide to the court as an alternative. Now, that provides the loopholes which are going to make it difficult in order for the state to be able to prove beyond reasonable doubt that the individuals that are in the accused box are indeed the ones that perpetrated the crime.
Yeah. State's case seems already to be on shaky ground. I mean, we heard shocking evidence. We heard, of course, that the investigating officer had confirmed that the gun found on one of the accused, who was, charged with possession, that gun had no links at all, in fact, to the Senzo Meyiwa case. That surely shows that, when you're talking about proving beyond reasonable doubt that state might be finding it difficult to indeed do so. So at this case, would you say in this where we are now, does the state's case seem to be, finding itself in a tricky situation?
For now, it's a bit difficult to piece all the pieces together. It's a bit fragmented, and to such an extent that you can't really make out as to tell me the story from start up until the end as to exactly what happened on that day, and show how these 5 individuals then fit in. if you are going to do that at the end of your case, well, it could work, but it's a lot easier and more appeasing to the ear, and also can be able to be more or less accepted by the presiding officer or the judge in this case, if you go from the start and you're able to provide the stories to exactly what happened. Now, if you are reading how the judge wants his things to be done, he do not want a person to beat around the bush. He wants a person to go straight to the point, provide the element in which you want to prove, and be able to prove those elements with evidence.
Yeah.
If you don't do that, you'll find yourself a bit on the back foot in terms of being able to try to convince him that indeed these individuals are guilty. So for now, I'll still lean towards the stage of saying, it seems as if the state has not gotten all its ducks in a row. There are certain few, and most importantly, pieces of information which are missing.
Yeah.
It could be looked at on the other way around, though, in terms of saying the state is trying to say, accused number 3, the person was found with a gun which was not used in this particular matter, has a habit of engaging in such activities. In fact, he is maybe the mastermind that provided the gun, and that's how he fits into this whole process, because even a gun was found in him. So it shows the prevalence of a certain illegality taking place. Now, that can't be relied upon, because the mere fact that you've been found an illegal gun does not mean that you deal with those illegal guns on a daily basis.
Yeah, but, does this not all, open up the gap for the court to start, contemplating on or looking at the second docket? And I know I always raise this with you, but, I think it's quite important that, we bring this to the fore. And I'm racking my brain trying to figure out why it's not being made as important an issue as it is. And it seems that, all that's coming out and all the evidence that we're hearing in court is pointing to the fact that at some point, this issue needs to be looked at.
In fact, that's the job of the state. The state is the dominant status in this instance.
Yeah.
So they are the ones that are able to prepare their case and be able to present it in a manner in which they deem it fit. Now, if you have 2 dockets, merge those 2 dockets together, take whatever that works for you and make sure that you're able to provide a very strong and formidable case. If you are going to leave out crucial information which is going to be detrimental to you and which would want to be raised by the external parties or the accused legal reps, that's when you're going to find yourself in the back foot. So I think the question then should be, why isn't the state using those 2 dockets in a proactive manner? Why isn't the state using all the witnesses that are there? You could have came up with much more formidable admissions and made it easier in order for you to prove this case. And from the side of the court, the court is an innocent bystander who is also an adjudicator. So the court will say, I will only look at information that has been submitted to me. I may have knowledge of information that does exist. However, if that information has not been provided through witnesses, through admissions, or any other acceptable manner in which the court is going to accept this evidence in, there's no way in which we are going to consider the evidence, regardless of the fact that it has been mentioned earlier. So there are very few, if not none, instances in which the court would say, give me the context of docket number 2, I want to consider all those things too. The court is simply going to say, I'm going to listen to what you are telling me as a prosecution, and I'm also going to listen to what the defense is telling me. And if I can see that there are other possibilities, there are other stances or manners in which the sequence of events could have taken place, I have no choice than to acquit these particular individuals, because you would have failed in your duty as a state to prove your case beyond reasonable doubt.
Just, on a side note, and, this might not necessarily have anything to do with what's being discussed at the trial at the moment. It seems that Senzo Meyiwa's last moments might have been, quite excruciating, that he might have been actually alive the whole time while there were deliberations and arguments about, whether to send him to hospital or whatever that situation is. But is there possibly a case to answer for where one could perhaps argue some sort of negligence on the side of those that were present, if they would have had an opportunity to call and ask for help and they didn't take that opportunity, even if we're saying that they had nothing to do with him, being shot and him being murdered. But is this a case to answer for, in that there might have been some sort of negligence by not taking a person who was so seriously injured to the hospital or calling in time? Or is there no case to answer for in that regard?
On the legal side, There's no legal duty that does exist in which there was no positive action in which we were engaged in that has placed a person in a situation where they need medical assistance. So if I'm not the one who shot the individual,
Yeah.
I have no obligation in order for me to take them to hospital. However, on a moral basis, then there is. You are not dealing with just any other individual here. You're dealing with your friend. You are dealing with the person who, at the time, you regarded as your partner. So you ought to do what a reasonable person in your shoes would have done. Firstly, you have a problem that's existed. Call for help. In the manner in which you are going to call for help is that you will either call the SAPS or you are going to call the ambulance so that you're able to take the individual to hospital. Any delay that takes place must have a valid explanation as to why the delay has taken place, and it must be able to absolve you at the end of the day. If it hasn't done so, then it does create the impression, and that will bolster the case of the defense of saying, maybe you had ulterior motives when you acted in this particular manner.
Right.
Maybe the manner in which you have been narrating the story to the police is not the correct one. It does not fit in together as to how a sequence of events of someone who has had their friends, their partners shot, ought or would have behaved in those particular instances. And that's the part that you need to answer. And that's the part in which I would have expected the investigating officers and also the prosecution to be able to deal with during the prep stage of all the witnesses that came in as called by the state.
All right, I know I digress there. So let me come back to the police. Would it be fair for the public, and I know there have been discussions back and forth about this, where some of the public have said, it seems that the police themselves were involved, and that is not necessarily, as we earlier discussed, maybe a situation of incompetence. And I mean, we're also talking about police who have been police for a very long time. We've dealt with crime scenes for a long time. The fact that a senior policeman doesn't see the need to take, swabs of kitchen door because other people have touched it. I mean, things like that. Would it be fair for the analysis of the public to be, well, it does seem as though there was some sort of hand in there by the police?
It would be, but more fair in the instance of saying that the police maybe were negligent, maybe overwhelmed by the matter in which they were dealing in, the magnitude of the matter, the person who was involved. It's not every day in which they would come in close contact with the family or with a scene which is similar to that one. So it may lead to a situation where a person is going to throw away all the skills and the learnings that they have done or they've undergone and simply do things in a haphazard manner.
Yeah.
But it does not take away the fact that at the end of the day, they are professionals and they ought to act in a manner which is professional. And they have certainly dropped the ball in many instances in terms of your normal procedures that ought to be followed so that you're able to engage in the process of elimination in order for you to find the truth. They've made it much difficult in order for the state to be able to prove this particular matter.
Yeah.
And if anything losing, or if the state would lose this matter, I think that they're going to lose it purely based on the work that has been done by the police, the lack of professionalism in certain instances, and basic methods of making sure that you're able to investigate properly, protect the crime scene, collect as much information as possible, record it, make sure that the chain evidence is recorded in a manner in which, when you need to go and present it in court, is going to be coherent, so that you're able to show that you've done all you could to make sure that you, as an independent third party, you came into the scene, extracted what you need to extract, and you're providing proof or an accurate report of what actually happened. And those sequence of events that take place in those instances point to the individuals who are sitting in the accused box as the perpetrators.
I mean, you talk about normal procedures, but it seems that there were quite a few abnormal procedures. For example, we're hearing that there will be testifying by Kelly Khumalo's police officer uncle, Themba Khumalo, who we understand reportedly stood guard at the Foslera's home after Senzo Meyiwa was murdered. How important is his testifying, and what could he contribute to what is already being said? And I mean, that is a strange situation, isn't it? Why would you call your policeman uncle to come and guard the house when there are policemen actually busy there anyway?
Definitely, and I think it would move towards the narrative of the defense in terms of saying you are still protecting or finding ways to not telling us the truth. You know what happened on that day. You're deeply involved in the manner in which the former goalkeeper of Orlando Pirates died, but you're not telling us information which is crucial to us.
Yeah.
Hence, why you even had your uncle stand guard and not allow normal SAPS members to be able to do that particular job. So in this case, the state would be saying, I'm trying to say that the integrity of the crime scene was protected through this individual, not just any individual, a person who's an SAPS member, fully knows and understands the procedures that must be done. But most importantly, the most important question would be, why didn't you get independent members of African police that were called to attend to the crime scene, to protect the crime scene so that the integrity of whatever that has been found there is protected? Now, the narrative of the defense still says there are people that were in the house that were involved, and they even had the opportunity of adding or manipulating the crime scene. Hence, we find ourselves in a situation in which the crime scene of the report which has been presented to the court is not going to present an accurate picture. And part of that is due to the fact that there's been outside influence that just came in, and the introduction of that outside influence is trying to implicate their clients.
Yeah.
When these loopholes do exist, the court will have no option than to acquit the individuals that have been named as accused.
All right, I'm obviously going ahead of everyone here, but if the five are acquitted on these murder charges, what's likely to then happen after that? Because I think the last thing anyone would want is a situation where we have a cold case, we don't know who killed him, we don't have an answer. But what's the likely step after that? And I want to go back to the fact that, given the fact that we do have another docket on this matter.
Well, there are a number of scenarios that can happen. Firstly, they can be acquitted using Section 174 of the Criminal Procedure Act. They can come back and say the state has failed to provide or prove all the elements that are there.
Yeah.
They've got nothing to answer to. That's the worst form of defeat that could happen to the prosecution. Or they could be acquitted after they've provided their own evidence, their own version, and the court simply comes to the conclusion of saying that we believe you as the accused more than we believe the state. The second one is that once that particular process has happened, yes, the state can go and prosecute other individuals that may be implicated using the information that is there. But from a tactics point of view, it then means that whoever is going to be prosecuted, you will still call the same witnesses. There's only one forensic expert that went to the scene. There's only two police that attended the scene in the first place. There are only 4 or 5 individuals that were in the house. So when they come back, they will be regurgitating the information, the evidence that they provided earlier. And if they are digressing or adding more information, then the question would be, at what point are you lying? Were you lying at the initial stage, or are you lying now? Why are you changing the information that you have as causing the state's case to collapse? Which is why, by the way, there are other suggestions that took place earlier on in the year or when the trial was starting, in terms of saying that go through docket number 2, and in instances in which there is conflict, and there's instances in which there may be individuals who are lying under oath, make sure that you are able to charge them with perjury altogether with the individuals that are in the witness box, so that you hold one set of witnesses to deal with every single element or every single person that you think must be found guilty in terms of these proceedings. If you separate those trials unnecessarily, you run the risk of your witnesses suffering from fatigue. You run the risk of those witnesses either passing away. You run the risk of evidence diminishing or no longer being available to you so that you can be able to use it. So you are going to end up with a family or your family saying that we still don't have the answer as to who shot our beloved son. So at the end of the day, make sure that your strategy speaks directly to what you are looking for. And if it means that you are going to have 9 accused or 9 individuals in the witness box, do so, even if you charge them with different crimes. Because all you want as the state is to drill down to finding out the truth. And if it means that you charge all of them, do exactly that, because the truth must come out at the end of the day.
All right, Mr. Zikalala, I know I asked you to touch on very many different topics, but as always, you've done an incredible job. Mpumelelo Zikalala, it's always a pleasure having you here on SABC News, a legal analyst and attorney at Zikalala Attorneys, really giving us a wrap-up of this week's goings-on, of course, at the Senzo Meyiwa Murder Trial.